for that.
Yeah. It's in Title 37. So I'm just kind of asking for support on that. That is just.
Okay.
So a lot of licensing statutes in the past have used good moral character and fitness, which we have had some difficulty with, if that's the basis of a complaint or discipline is how does anybody define good moral character? Or fitness is not as objective as some other measures. So the measures put in by the legislature it's still subjective, but it gives the board more guidance.
That's so whatever that language is the one that I'm hoping that we can, it serves as a model and we can model off of that. So once you pull that up, I appreciate it.
Well, I just asked our legal counsel if she can send us that new the new criteria, that new language, that new legislation that was approved by the legislature last year. So she's going to email that to us.
That's what you were.
Yeah, that's what I just asked her. I just like to have that reference. I can always go back and review that when needed.
So while Sherry is looking at that, what do you think about fit for work? Like, is it fit? Is it like, what is?
I guess she's gonna look at it, but fit for work.
What is the
See, I don't like
problematic language?
It's fitness and fit.
So the fit part.
Yeah, it's like, what is fitness? I don't, what is good moral character? That bothers me. Like, it's so subjective.
But isn't the fitness for duty an HR?
And that's what she's trying to make sure. Yeah,
it's been in every HR thing I've ever seen.
I know what you're saying.
Good moral character, I could
lean towards fitness more than good moral character. That good moral character has gotten a lot of people of color arrested, put in jail, convicted, sent to the electric chair, death penalty for that good moral character stuff. I just can't rest with that.
The new board member training that I went to, the trainer said, y'all need to look at taking that out, the good moral character, because that is so subjective.
FYI, that's in your practice act.
I know, we know, because and it's in a lot of other states' practice act too, but the movement is to work against that,
Do we know,
I know.
Something else that encompasses what we're trying to capture in other words?
She's trying to pull something up. I think that we have already.
I was just wondering if anyone else knows.
Anybody else? That is a.
Because I've always heard, I don't know about necessarily the good moral character.
Fitness is there. I could keep fitness if we get rid of good moral character. You know what I mean? Like, because I get it. She said fitness is in HR and everything we do is still somewhat subjective.
So please entertain me with the why. What's wrong with good moral character?
It's objective. It's
because you don't have it.
Exactly. Exactly.
Well, like,
now it's like, what you talking about?
In the old days, it was immoral to have a child out of wedlock. Today, it's more acceptable, right? So it's kind of like my morals and your morals. It's all subjective.
It's all subjective. You have your own kind of morals, and I mean that good moral character has really done some damage to people of color. So
she's right.
Okay, so Title 37, Section 2950 was amended in 2022 to state as follows. Notwithstanding any other provisions of law, so this supersedes anything that was in place before, a person shall not be disqualified or held ineligible to practice or engage in any trade, occupation, or profession for which a license, permit, or certificate is required to be issued by the state of Louisiana or any of its agencies or political subdivisions, solely or partly because of a prior criminal record, except in cases in which the conviction directly relates to the position of employment sought or the specific occupation, trade, or profession for which the license, permit, or certificate is sought. To determine this, the board shall consider, or the licensing agency shall consider, one, the nature and seriousness of the offense, which you all routinely discuss when you're looking at applications.
Okay.
The nature of the specific duties and responsibilities for which the license permit or certificate would be required, which is also something that you all routinely discuss, that counseling or in the school setting or those sorts of things. The amount of time that has passed since the conviction, which is another thing that you all always consider. Facts relevant to the circumstances of the offense, including any aggravating or mitigating circumstances or social conditions surrounding the commission of the offense. And evidence of rehabilitation or treatment undertaken by the person since the conviction.
So why can't we just say that?
So I'm
Why can't we
saying
be
that
specific?
maybe we could just reference
Okay,
that the burden should be on the applicant to provide documentation regarding the items that the board's supposed to look at in the statute.
so
I'm sorry,
Go ahead, Jane.
can you repeat from solely to before you started listing the numbers? It was-
Okay.
You said solely or partly because of a prior,
Criminal record,
okay?
except in cases in which the conviction directly relates to the position of employment sought or the specific occupation, trade, or profession for which the license permit or certificate is sought.
Okay, I got it, okay.
So, I mean, since I've been working with you all, we've had examples of, cases where it was Medicaid fraud or
Right.
documentation of services that didn't occur, different things that would relate to the position sought. And then we have, shoplifting that happened 10 years ago or whatever. So this gives I think that these are the things that the boards routinely consider, but it's now listed that you have to consider these things.
so how do we say refer to
Well, I think,
this is where we need you to wordsmith this, right?
Right.
From the legal perspective.
so you're trying to make it clear that it's the applicant's responsibility to submit documentation to the board sufficient to establish that they meet the criteria in the statute.
Okay, so that's what we need you to do, though. That's what I'm saying, Sherry. So we need you to be able to wordsmith it to be inclusive of that language for
I
us.
would just use the statute number.
Okay,
And
so
that way, if the legislature amends it this year to add another thing to the list or whatever, then we don't have to go back and
And
amend
keep
it.
So let me
changes.
try,
Let's do that.
Right, it's,
So it would potentially say it's the applicant's responsibility to submit documentation to the board sufficient to establish that the applicant meets the criteria of Title 372950.
That's
that's
what it's gonna
sufficient. Yeah, that's sufficient.
Okay.
You never have to change it again.
Right.
It covers it moving forward,
And that would take out moral character and fitness to practice?
but we don't. Now, here's the problem with that. You have to look at the Practice Act, and Emily has stated that. Good moral character is in the Practice Act. I know you may want to remove it.
No, I mean, in this
But we have-
one sentence, would that take that out?
Yes.
Yeah, okay.
Okay, but we.
But it still will be in the practice.
Yeah, I know, just about to say that.
I wasn't saying that, I'm talking about just this one sentence.
Yeah, I understand what you're saying.
You're gonna make the motion and it's gonna just change that whole sentence, right?
Yeah, I can go, if anyone doesn't have any more discussion.
Any discussion
Well,
on
I
that?
have one more, I have something I would like to say. So, you know how, the public, always ask us to maintain consistency across the board? We're taking language out, and I know it may be the best decision for our licensees and what's best for the public. We're about to remove language. Okay? But it was consistent across the board. It matched the Practice Act. Now we're removing language that may be best.
Maybe it should come out to practice that.
I think that's
Yeah.
what.
That's where you're going
You gotta
with,
start
but we
somewhere.
can't.
You gotta start
Gotta
somewhere.
start somewhere.
So if you
I
start
agree.
here because you're making the changes here, then maybe you change the Practice Act. Because, I mean, we can't look at that like it's the Bible. The Bible can't be changed. It is what it is. But as things change in practice, then you're going to have to make changes to the Practice Act. So maybe that's just one of them.
Right.
I'll let you go with it there. I'm looking at it from a different perspective, but I understand your point of view. I may not agree with it, but I do believe
So
it
Trinity,
changed.
this is,
Yes.
okay, so once upon a time, women or people of color couldn't vote in we live, right? And then
Yes,
the federal government said, yes, they can.
yes,
The state law still said they couldn't.
exactly.
So you're saying the federal government shouldn't have did it because the state law still said, you know what I mean? Like
No,
that's
no,
what
no,
we're
no,
doing.
because I know,
I'm just trying to give you a new frame of
Yes.
reference.
It's
Like,
the chicken and the egg.
yeah, right, okay.
And even the Bible, if we're gonna get biblical.
Oh, no.
Oh.
please
Yeah, yeah, see, and I was,
That's point of order, y'all, love y'all, that's it, love y'all, need the motion, going in there. Here we- So,
Okay, so
were you going to your motion?
Yes.
Y'all can do that.
I'd like to make a motion to strike from K1, has a good moral character and fitness to practice social work, and add to K1 after applicant, meet criteria of Title 37, 2950.
Second.
Is there a second? Second by Evan. Any public comment pertaining to that motion on the floor? All
No.
right. Objections or abstentions to that motion? Hearing none, motion carried. All right, y'all.
Just for good measure, then, I don't think that we adopted the fixing the blue part in J. So at this point, I'll move to adopt, blue text in, revised section 309J.
Yay, okay. All right, moved by Evan to adopt the wording in 309J, second by Candice. Public comment regarding that motion on the floor. Objections or abstentions to that motion on the floor? Hearing none, motion carries. Trinity?
I just wanted to say before you made the motion, Madam Chair, it would have been great for the public to know what it is that we just did by having our Rules Committee Chair read it for the public.
Read which one?
What we just
The
did.
blue?
Yeah.
Did that earlier.
He did. He did it a little earlier.
Right when he was, right when he made the motion.
Oh, okay,
That's
because I know he
usually we
did
do
it.
that.
Okay.
That's,
All
But
right,
it's-
so I will know for the record that the months have changed. It was listed April, May, or June. The months are being changed to June, July, and August to align with our renewal period, okay? So that's what it was. All right. Moving to anything else in chapter 3?
I just want to also know, sorry. So this is one thing that I think was left out, but Emily and I have discussed this and we cannot remember if this portion was adopted, which is why we added it here and I wanted to let y'all know. In 313A, it was our recollection that we made the fees non-refundable, but I could not verify it one way or the other, which is why I included it in here for y'all to consider again, just to make absolutely sure we weren't sending something off for promulgation that y'all had not considered.
I'll make a motion for that.
All right, go ahead.
I'll make a motion that the fees are non-refundable for the RSW, LMSW, CSW, LCSW.
A second.
Okay, that's second. Motion made by Trinity, second by Board. Public comment to that motion. Objections or abstentions? Hearing none, motion carries.
So there's no lapse renewal fee for any of the lapses?
I think that's everyone. We have the LCSW, LMSW.
Oh, okay.
So,
Okay.
That's at the top line, number
Okay.
10.
So it just costs that.
You see the blue in 329B? I corrected that because that was like an incorrect reference. It said pursuant to the following rules, when in actuality, we were just talking about that section. So that was something, a change in the original language that was adopted, but it was more of a clarification. I just wanted y'all to know that.
Make a motion to adopt the change.
We could, or we can wait to the end and make it global. I wanted to tell y'all that too, but if you wanna make it, make it. Go ahead. Why, since you,
Global, I'm ready.
talking about 329B. And really for all the blue, right, Candice, like if you see the blue.
Yeah, we can just make a motion at the end.
Mhm.
That's all that is.
And I did the blue like last night, so I will let y'all know where the blue came from.
And just for clarification, the blue is not changing the rule, it's like adding so, a comma, it's that kind
Yeah,
of change. It's grammatical stuff, it's not anything that the board has already approved.
And Evan, if we go back, I see where you're at 329. If we go back a page before, I see in the box where it has the fees, where it says the lapse renewal fees for like the LCSWs, LMSWs, RSWs, and we go down to number 17 where it has written verification of license certificate or registration. We did increase it from the $5 to the $25.
Right.
Okay, cool. I just wanted to make sure.
We had a meeting of the rules committee where we considered the fee increase, and that's where we did that. Awesome, yeah.
So we are we're still in chapter 3.
In chapter 3, the only thing that probably might need some looking at is the 329 on public comments. In light of the change in the law to the open meeting, make sure that everything's consistent when the rule is prepared for the virtual participation.
Was it any?
Everything at 329.
Okay.
Speaking for D, I think we submitted to a meeting with virtually. But sure, we already did this.
Right, but if there's anything that changes, because if there's a rule on virtual meetings or virtual participation, then
So
we
you
just need to
want
make
that
sure it's
verbiage
aligned.
Mhm. Oh, and one thing I found in this that we missed as well, in 329C, it was originally written on line 2 as the close of business, and it was amended to say 5 p.m. on the day prior to the meeting.
Yeah, because I remember y'all wanted specific time.
Mhm.
Because close of business is also subjective.
Right.
I might close my business at 4, you may close yours at 6.
Right.
So the rule want them to be, we were talking about specific time. So 5 p.m., is y'all putting CST, Central Standard Time too? I'm just saying.
Yeah.
No, I didn't put that.
that
Yeah, you might want to put CST on there.
Because when I say I email within a business day, I close at 11:59 p.m. So you might get it at 11:45.
So that would be 329C. Emails will be received up to the close, up to 5 p.m. CST prior to the meeting. So if, that would be a motion. I can't make that, but that's what y'all are saying.
Wait, I thought did y'all already approve that and I just missed it?
Yeah, that's what it was, yeah.
Oh, okay.
Yeah.
But not the central time thing.
Oh, not Central Time.
Do I need a motion?
I will put CST, yeah, but yeah, let's put the CST.
Central Standard Time today.
So it should, just
Doing something else.
not to be that guy, but it can't be Central Standard
Yeah.
Time, because what if you're in daylight saving time?
Right.
Yeah.
So it would just have to be Central Time.
Oh,
Central
Central.
Time,
Central
sorry.
Time.
I motion to include Central Time
Okay.
after PM.
I second that.
Is it?
Yeah, motion made by, Candice to add Central Time, seconded by Cora. Any public comment?
Thank you.
Any objections or abstentions? Hearing none, motion carries. That was to 329C. Okay.
I have a quick question, Clark. For 327, the discrimination, is that the area that we tried to change before and it was taken out at the last meeting, or was that, am I recalling something?
This is 327.
Yeah.
This was added by the Rules Committee as part of the Practice Act revisions section, though it was not included in the Practice Act.
Okay, so, it was the practice act.
Yeah, okay.
Differing abilities, can you elaborate?
That's just the term.
That's the.
Inclusive term for disabilities.
Oh, okay.
We don't use disabilities anymore.
Oh, okay.
We have abilities.
Okay. Abilities.
There's so many nuances.
Yeah, because I know we have different pronouns and things like that, and there's some.
Oh, there's much
I'm
more.
volunteering with class. I'm like, wait, what is this now? And
Yeah.
so, okay.
You can get a
And I have a book that I
definitely,
go
you
by
can get
now
a
with
dictionary.
some of the young
And
people.
can't see.
And I'm
Right, but to that point, we still must recognize and respect identity first language.
yes,
There's identity first language and person first language, and in
Yes.
identity first language, the individual can select and choose what they wish to be.
and that's how you refer
used,
to them.
and they refer. So
Yes.
although we are saying differing abilities, there are people in the world that embrace
They do.
what they consider is their own identity.
Exactly.
And particularly individuals with identity first. So,
And that's why I
but
have a
different
book.
abilities is okay. I see it in here. All right.
There's not a whole lot of change to, chapter 5, except to, conform with the change of legal law.
Okay. So that's it for chapter 3, y'all. Okay. So now chapter 5.
She just said.
That was just to
Oh,
update to
okay.
comply with the law.
Oh, just comply with the law. Okay. So now chapter 7.
Chapter 7, okay, this, is the Recovery Professional Program. And it adds, a provision in C is the, substantive provision that, you could require, if there's verifiable information, putting the applicant's ability in question to perform their job, then you could request an alcohol or drug screening.
That's what it can submit to that physical and mental health evaluation.
In connection with an investigation.
I like
It
that.
changes the term impaired to recovering, and 703 added the word medical.
I like that.
So those are all legally appropriate revisions.
Excuse me, Cheryl, thank you.
And then the change of.
Sorry.
There's a change in title to 705, that's just to give it a little bit more clarity.
So actually, that was an error because 703 was purpose. And then I think, Emily, when you redid it, you copied 703 into 705. So I went back to check. The
Okay.
original title is 705 Program Implementation.
Oh,
Yeah.
Right.
That's okay.
that's what I get tired of going up there and saying, telling it to insert that little squiggly thing, and so. So I was, sorry.
The symbol. This, these are changes to the program, the Recovering Professional Program, I think to clarify, what the practice has been.
It's exciting.
All right. Anything else with chapter 7? Okay. Chapter 9.
Sherry, we had reviewed for a long time. Yeah, you and I went through it, yeah.
Yeah, this is your procedure for, complaints and, yeah, your disciplinary process.
I made, when I was re-reviewing it last night, just so y'all know, I can ask about the blue. 909, I fixed, I thought was a typo. I changed it from chapter to part. For the discipline under the whole set of rules, not just the procedural chapter. See a couple of like typo and grammatical
I
things.
see F to assist in, and that's correct, instead of in,
Yeah. 927, I just moved those words around to make it all consistent. Because you see how it says board member, prosecuting officer, or hearing officer in two. Well, in one, for some reason, it said board member, hearing officer, prosecuting officer, which I thought it made me, I didn't like it. I didn't like the fact that it was not the same. One thing though I did change, which is not in the it was not in the original, and only because when I was reviewing it last night, I found it and I thought that it was a problem. Was in 971 compliance hearing. And then the 971A, you see how on the third line it says, or the second line to the third line, to appeal, the applicant or licensee must submit a written notice of appeal to the administrator within 10 calendar days. That sentence just ended. So it was not clear 10 calendar days from what.
okay.
And when I was looking at it last night, because I hadn't read these in a long time, because what happened was we undertook a rewrite of the procedural rules a long time ago under a previous set of procedural rules under a previous board council. And then we rewrote them, and then I gave them to Sherry a long time ago, and Sherry said, you can actually simplify a lot of this, which we did. And so that's the result of this. But I hadn't looked at them in probably 2 years. So that's why I'm recommending that we make that change in 971. It's not originally adopted by the board, but it's something that was particularly
That
important.
one, change it from mailing to receiving, or because mailing is like what we did. So 10 days from the day I mailed it,
Mhm.
I have to get a response from you, but I don't know when you received it.
That's what I was about to say.
But it's certified, right? So
So if you don't
It
go
doesn't
to
speak.
the post office to receive, to sign for the certified mail.
is it when, I don't, and this is my, when does the calendar start?
Like, what is?
Does it start the 10 days from the day I know I sent it to the post office? But I don't, or the 10 day, do you get 10 days after you received it?
That's what I was
To
gonna say
respond.
too. Because it's not stipulated, it's not stated in it. So what we don't know if it's certified mail or not. So we're going by the date that,
Because
are we going by the
Emily
date
said
that Emily sent it, or the date that's postmarked on the envelope, and that that licensee has to keep that envelope to show proof? So how are we determining this? Is it the date that's on the letter itself? And then dear licensee, whomever, or the postmark date. And me, I would keep that document and that envelope to say, hey, this is the date that it was postmarked.
doesn't necessarily mean anything.
Right.
My mail person bundles my mail at my office. It comes.
See, when you do it certified.
No, I know, I'm saying if
we
it
don't
does,
know.
I'm just saying as far as if it just, she comes twice a week. But
They
they,
don't have any alternative
I'm
land.
just saying receiving it.
Well, the receiving is a problem.
The receiving is a problem too.
And the Administrative Procedures Act with respect to appealing the decision to court is from when the agency sends it.
Okay.
And that's problematic too, because I've represented clients with agencies send it doesn't mean it arrived.
Right.
But people that, owe people money or are in trouble with their licensing board, they don't pick up their certified mail. So that's problematic. They're never gonna receive it because they're never gonna get that mail. And sometimes it's not even the correct address.
Mhm.
But we
our obligation is to send in certified mail to the address they have on file with us,
Right.
but they may never go to that address.
So do you have any proposals?
So,
I should propose to keep it the same, 'cause
that I don't know that we've had a lot of problems with people sending in a request. I'm not aware of any real.
I mean, we've denied one that, but it was like way past 10 days. If they're like
No, I was really tired.
close to the 10 days,
Mhm.
we've granted them the rehearing.
Okay.
Yeah, I don't know that we are frequently denying them.
No, I
If
can
they get
remember
it here, but it's gotta be to someday, with the new system, we might be able to notify them electronically or something, put it in their wallet so that
Mhm.
even if they didn't get the certified mail, they would get the notice.
It's somebody that came for a compliance hearing.
They know.
They know they're gonna get a response,
Mhm.
a written response. So they're normally calling the
Calling.
next week to
Well,
ask.
if we say at the compliance hearing, you will get a written response will be within 15 days, but we send it out the same day, they might not start looking or getting concerned until 15 days, but we're giving them 10 days.
Well, it's 10 days after.
10 days after, but if I sent
Right.
it out yesterday, their 10 days are gonna go in within the 15 that they're not gonna even start looking or getting concerned. Because we said within 15 days.
So why don't we say 15 days of the date it was mailed?
On Monday. I
Why
mean, I
don't
think
we
they're
give them
looking for the
5
mail
more
on
days
Monday.
And then say 15 days of the date it was mailed.
So in a compliance hearing, it's somebody that was denied something that they asked for. So they're coming to the compliance to urge you to grant whatever was denied. And I think because you all meet on Friday and you end on Friday and sometimes meet on Saturday, it's unrealistic. We can't get those decisions out that day.
Mhm.
And we're trying to we've been getting them out on a 15th day, but we're trying to reduce that time frame. But those people are looking for the, because they asked for the hearing. It's a little bit different from our disciplinary people that are trying to avoid us. Our compliance people, they're asking the board to do something that helps them get licensure or get credit for supervision or something. So it's not, it is a concern of communication, but I think for this group, you haven't, these are people looking for us more than us looking for them. I think it's more a problem probably on the discipline side.
Yeah.
So where are we leaving blue or what y'all doing? What's the proposed change if
There
this
is no
is not?
proposed, I think there was no better solution, is what I'm hearing.
But what I'm telling you is the blue was not in the original adopted by the.
Oh, yeah, we like the
So-
blue.
So you need to be able, at the end, we can either do a globalized motion or y'all make now to keep it. That's what he's saying. If y'all okay with the mailing of the limited panel's decision in that section, we would need a motion.
Okay, I'll move to adopt the changes to section 971.
Is there a second? Second by Bora. Any public comment? Any objections or abstentions? Hearing none, motion carries.
973A is something I didn't check before. It did not make sense the way that it was written. Which is why I was recommending to take notwithstanding subsection B.
Right, I remember even you talking about it's not having notwithstanding in there at all, because sometimes it can be confusing for the reader.
Yeah.
So I see why you have that in there. Y'all have any objections to that, notwithstanding being removed and putting a capital W there? Okay. All right, we can, if you want, we can either make that motion or, do a global one at the end, maybe.
Okay, so since this section, as Evan said before, we worked on this a long time ago. We have changed our prosecuting attorney.
Yes.
And I would think that before we send these for promulgation, that we would ask him to also look at it too, in case he has a better suggestion, or if there, that he feels needs to be addressed. Because it would be better for him to address it now rather than in the context of a case say, "Oh, that doesn't really work."
Right, and that would be this, chapter 9.
Yes, chapter 9.
Oh, yeah, all right, so,
If he thinks anything's unclear, we can certainly clarify it, or if he has any concern with the procedure.
so I really would like for us to make a motion to allow that to happen, because if he does need to make any revisions, he could bring it straight to the board. I don't want it to have to go back through rules and all of that, so we could just let him take a look and just give his revisions, correct? That's where I'm at. And then this is just for chapter 9, and that's because we have a new prosecuting attorney. We did let him look at this section. He does a lot of work around compliance hearing. All right,
So who's gonna make the motion?
you can still move it or,
So I make a motion to allow our prosecuting attorney, Mr. Raines, to review chapter 9 and make the necessary changes for LABSWE.
there's a second.
Second.
Second by Evan. Public comment pertaining to that motion? Objections or abstentions to that motion? Hearing none, motion carries.
Okay, so also in chapter 9, is section 979, which is a new section on removal of disciplinary flags. This is probably the only section that I had concern from a legal standpoint, because we do have pending litigation over the board's denial of removal of a disciplinary flag. We also are in the process of getting a new licensing system, and how things will be displayed in terms of licensure status might change slightly. So I would ask that we defer that 979 for maybe consideration at a later time, after the litigation is resolved and after the new system is put in place.
So the best thing, Sherry, to do would be to take 979 out
Out of this
proposed-
promulgation.
Right, so then we would renumber 981 to 979.
I heard your reasoning for wanting to remove it, but you think this could potentially impact I know there's pending litigation, but wouldn't this support the board as we're doing this? So other persons don't say or anyone doesn't say the board is just taking action with no guidance and no precedence?
I just don't know what the ruling is going to be or what issue it's going to specifically address. So that's why I'm requesting that it be removed at this time.
Would there be any would there be a negative impact if we did not remove it? Would there be anything harmful to the board? Any legality issues?
It's possible that it could maybe delay the promulgation process. Our rules have to go through the Occupational Licensing Review Committee, and I don't know how they would treat a rule that had, when they go through every rule in detail when you go before them. So that's a concern that might be something that they alter or question or.
Because of pending litigation? Or just in general?
Because of pending litigation, and also because we are going to go to a new system, and I don't know how it's actually going to look on the new system either, how that licensure status is going to look. So those are things that I think are kind of in flux.
So is that also a concern due to confidentiality? Even though if there's a disciplinary flag for a reason, we would want that to be public, wouldn't we?
That they are public records.
Exactly. So,
and you also have a reporting system. The national database is reporting system to potential employers.
Well, then I will at this time move to remove section 979 from this proposed promulgation.
Before anyone
And renumber, I'm sorry.
Can I just get a point of clarification before I'll object?
I'll withdraw,
Okay.
yeah.
So, is there something else the board can do to have something documented on what guides us when making those decisions about removing a disciplinary flag from public view only, going forward? Like, is there something else that we can do in the meantime if we take this out?
And that really is an issue too, that the prosecuting attorney needs to review as well from a legal standpoint, I believe.
But
Because the orders all say that they're public records.
right, so it's only, oh, I see what you're saying. Okay,
So I will at this time move to remove section 979 from this proposed promulgation and renumber that chapter.
Okay, it's been moved by Evans, seconded by Trinity. Any public comment pertaining to this motion?
I have one hand raised.
Okay, public?
Hand raised by Michelle Guidry.
You being recognized.
Hi, so I don't mind sharing this. I am the social worker you guys are talking about from the pending litigation. So my question to the board is why, my only concern is I don't want people who mean to do me harm to have access to my public records. I understand that there will always be a concern, I will always have to report this to certain entities, but I don't want someone, say in my personal life, to continue to have access to these records that means to do me harm. So I understand the board's concerns at this point, but I'm asking why would they be removed? Because I'm actually in the process of talking to my prior counsel and hiring new counsel for the litigation.
Any other public? Thank you, Ms. Guidry. Any other public comments? No public comments. Any objections or abstentions to the motion? Hearing none, motion carries. Go ahead, Candice.
Will the prosecutor attorney still review it now that we removed it?
Well, we can give him this draft. And so
He's gonna get all of chapter
It's a
9.
good.
Okay, I just want to make sure that he.
Oh, that'll be out. Yeah, let's give him that draft too. So let's give him that draft
Thank you.
so he can have it. Okay. All right, now we're on chapter 11.
Okay, I have one more
Oh,
thing.
I'm sorry, chapter 9,
The next one on 981, I just think needs a little bit of clarification. This is a letter of concern or education, which is issued to a licensee when there's not sufficient evidence to support a complaint. And so it's kind of technical, but the board may issue a letter of concern or education when there is, we're saying no evidence, it would be insufficient evidence of a violation.
You're saying it should be insufficient?
Correct.
So that sounds like that's a grammar issue, so that's okay. This is where we discussed this.
It's a little bit,
It's different.
Yeah.
you're saying there's no evidence,
There
whereas
may be some evidence, but not
sometimes
enough.
we have, and you might recall in the past, sometimes we have someone that sends in a complaint, they make allegations against the social worker, but then.
Oh, I know what
there's no
insufficient means.
witnesses.
I know what insufficient
Right.
means, but I'm saying that it's a minor change, so. Does anybody have any concerns about it moving from no to insufficient?
Need a motion?
I don't, but I have a question regarding the.
Okay.
It says
Okay,
notwithstanding.
wait, are we still,
Okay.
let's see if that, and then we'll move to B, I promise.
Go ahead.
So let's see, and do we have a motion about A, which Sherry just mentioned?
Motion to change no to insufficient.
Okay, so it's been moved by Candice to change the word no to insufficient. Second by Jamie. Any public comments?
No.
Objections or abstention? Hearing none, motion carries. Okay, now Trinity, B.
So B, notwithstanding the board's reporting obligations under 45 CFR 60.4 ETSEQ, a letter of concern or education will not result in a disciplinary flag as that term is described in this chapter. Are we keeping that or are we removing it in regard to 979? We just stripped that from this
There's an
That doesn't
easy,
have anything to do.
Not connected.
I know it's, and I know we're just educating them and we're just informing them, but I seen that in there, so that was my question. I seen disciplinary flag. And that's the reason why.
Oh, your point is that since we're removing 979,
And then-
and we still have the language of disciplinary
Yes.
flag and
Are
981,
we removing that?
should that come out too?
An easy way to fix it is to say a letter of concern or education, is not discipline.
That's fine, but
I don't understand the
Okay.
conflict.
Because we are, because we're removing, we're not even submitting anything about disciplinary flag.
Also, disciplinary flag is nowhere else in the statute,
Nowhere in that,
we're removing that whole section.
I understand that,
And so that's why they're saying we're removing.
but we still have disciplinary flags, right? So this is not talking about that, this is talking about all the other disciplinary flags, right? Is it me?
I'm agreeing with you, Jamie.
Okay.
It's not just you.
So,
Because 979 was just about how to remove your disciplinary flag. It did not speak to how do you get a disciplinary
Correct.
flag.
So your point is because we still, we should leave it in there. His point, I hear both of y'all, right? Because I'm kind of like in the middle with y'all sometimes. I hear his point of why we still have it if we're moving the whole section out. But I hear your point in saying, well, we still have disciplinary flags. Just because we're moving the section out doesn't mean it's not there. So
And the section we're removing is saying
removal
Correct.
of it, disciplinary flag. It's not saying everything. So
It's not saying we're never gonna have disciplinary flags in
Right.
any of the part.
But to Evan's
See,
point,
there's Evan.
In terms of the data bank, what you have to report to them is discipline. So if a letter of education is not considered discipline, then it wouldn't go to the data bank. You're just saying that somebody alleged that you did this, and you should be knowledgeable that there's a rule that says you can't do that. But we don't have any proof that you did it. It's just giving information that might help the social worker avoid.
So can I make a
so
motion?
hold on, not yet. Evan.
I have proposed language I think might fix it. So we change B, we remove most of it, and you essentially replace it with a letter of concern or education is not discipline under the Practice Act or this part. Is that
Okay.
what we're talking
That's
about?
fine.
I like that.
Yeah, that sounds great.
Okay, say it again, Evan, for the record.
Sure, so what's gonna be renumbered as 979, it's existing 981. B, you replace what's in B right now with a letter of concern or education is not discipline under the Practice Act or this part.
Would it be, basically, is not classified as discipline?
Yeah.
Well, it's not discipline because you can't.
Not discipline.
To discipline someone, you have to give them notice of what the allegations are, and then you have to prove that that happened unless they consent. So it's just, somebody, you're just telling them, be aware that there's this rule, basically, right? But there's insufficient evidence to prove that what is alleged in the complaint ever occurred.
So is that a motion?
It is a motion, but I need to add to that motion as well, so let me just make the whole motion in
Make the
general.
motion.
Because I noticed in the title, we now need to remove national database reporting, because that doesn't have anything to do with it. So I, at this point, move to amend what's existing section 981B to read as follows, quote, a letter of concern or education is not disciplined under the Practice Act or this part, and to amend the title to remove national database report.
Second.
Okay, been moved by Evan, second by Trinity. Any public comment pertaining to that motion? Objections or abstentions? Hearing none, motion carries.
Okay, so then chapter 11 is focused on continuing education, and you all made some changes. The board made some changes to continuing education of the organizations. So that section 1103 is there, and also you added to 1105 some clarifications to the credit for attending committee meetings and board meetings. Also added 11 and 7 to grant continuing education teaching credit. It adds a new section. And then also 1111 verifies the election period. Distance or virtual education.
Madam Chair, can I just say something?
Yes.
The CE committee just would like to thank the rules committee because we had no additional recommendations for you at all. So we just wanted to thank rules.
Theory to summarize the legal concerns of chapter 11.
No.
Great job. We picked it apart.
Remembering the continuing education teaching credit, I don't have a problem with it, I really did. But didn't say we're taking it out or something? Did I wanted to review something? Or maybe it went back to something. Okay.
So I know exactly what you're talking about. It was originally considered at the April 28th meeting, and it was recommitted to rules to fix some stuff, and then reported back again and adopted July 7th.
Okay.
Yeah.
What's the deadline when you all, what day? I mean, when do we start over?
September 1st is the Monday. Okay.
And, yeah, just explain, yeah, go ahead.
So if you, let's just say you get your LCS, then exam in July. You don't.
Oh, that's the exam, got it, no, that
You don't
cleared that
have
up,
to get 10.
that's the exam, that's not to the exam, gotcha, thank you, got it. All right,
Talking about the program.
Yeah.
right,
That's what I'm trying to.
you was, did you get a little lost?
Well, I had to figure it out.
Did you? Okay, well, that's, I wasn't.
I wasn't gonna say it out loud.
I was doing the same thing.
All right, I'm just glad I'm not in it on my own, cause it's kinda,
You got covered.
all right,
Should explain the.
okay. I don't even know why it's there, but I'm gonna just.
Well, you know, we've been credentialed so long, it's kind of hard to go back to even think of that mindset, but.
Maybe a statement of
It's
how
a great-
that should be in there, because if all of us were going, wait a minute, what?
I'm telling you, I'm glad I wasn't by
But if you
myself,
read-
you know.
I thought that was a total
Sense to me, but probably because I got my license in July.
But there's a statement
I remember,
here.
like, oh, wait, I don't have to do anything.
A, continuing education hours are prorated as follows during the initial year of registration, certification, or licensure. So, it states it.
You mean like the explanation?
The explanation is in A, and then if you look at June, July, or August, so if your license was administered, June, July, or August, then you are not required to obtain any.
Anyone didn't understand, I think they didn't understand the rationale for
Yeah,
it.
we had to,
Like, why would
Well,
you?
she was saying she needed a statement. She would like to see a statement.
well, I'm just wondering if all,
But I understand.
that is that because we're old
Yes, I
and
do.
Yes, I
forgetful.
think so.
It only happens one time in your whole experience,
Yeah.
so you forget.
Yeah,
Like, it's the first time you get that license, and then
Does it go out when people get it? Do they get that information?
with your license, you get a letter that
Yeah,
explains
so
it.
go- yeah.
Yeah.
yeah, it's just us.
Yeah.
And it does say in the title that it's prorated for initial years of certification, so
It comes right with your license.
we probably just jump to the table and got confused.
All right, y'all, I can't believe I'm not.
Believe it.
Where the wood at, where the wood
You're
at?
not jinxing.
We still have,
We got an agenda item left.
we still have to, get a motion to accept the changes.
I'm sorry, you can go back to the prorated then.
Oh, you don't want this, so you could, are you feeling confused about it?
I'm not confused at all, but I'm wondering if it's somewhere else, or do we need to add something about the clinical and ethics piece? Like with the, not ethics, because you got 2 years, but the clinical part, like that half of those 10, or does it not matter? Like if you have to do 10, March, April, and May, does it not matter what type of hours they are? Or like there's Emily over there about the.
I've gotten that question before, and it's just, to me, it just makes it more difficult
Okay.
for the licensee and for staff to try to figure out when this person initially was licensed. And so did they get 2 or did they get 5? It's like, just get 10 hours of continuing education.
No matter
make
what
sure-
they, okay,
Yeah.
okay, that's fine.
Next year.
Yeah.
Yeah,
You got the rest of your career to.
yeah, I think that first year should be, whoop.
Yeah.
All right, y'all, did we get it all? Before I ask for a motion to accept, the changes that were made that did not already have motions that went through for approval? In this document, did we get it all out? We got all out?
Yes.
Okay, good.
Very
All
well.
right. All right, so that motion, somebody has to make it.
I move to adopt the draft.
I second.
Oh, I got several
amended,
seconds
as
on,
amended,
as
as
amended,
amended,
as amended.
yeah.
Okay, so that was Evan Bora, you are secretary, you take that second. Any public comments? Any, objections or abstentions to that? Motion carries. I just really want to give a round of applause to like everybody pat each other for this body of work that this board has been able to get done. Thanks to everybody here, and also thanks to the public for the input, the committees who volunteer their time to come up here, to drive up here. All of the committees have input in this document, right? So this is the work of the board, the public, the licensee, and I want to take this time, and the staff as well, putting up with us, bothering them about different things, how to get it done, and our administrator for just honing in hard and just holding it down and getting this work to us. Thank you so much, y'all. This is a lot of work, and this is something to be really proud of. With that, we're going to move on to the next item in the agenda. Thank you, Sherry, our legal counsel, as well, because you still got some more stuff to do on it. I'll give you your thanks at the future meeting. All right. With that, we have another item on the agenda that we need to cover. And I promise I'm not going to say TJ or whatever I said. It is a committee to update the board member handbook and training documents. So y'all know there's a lot of work that we do here at the board. There's so much stuff that we do. And our policy and procedures committee has a lot of weight. They are working hard on developing policies. They go through fiscal matters. I mean, all of those checks and balances. And they had a heavy lift on their task and request to do. And so as board chair, I decided to pull some of that from them and let them focus on the body of work that they have been doing. I don't know if you've had any opportunities to witness and watch their meetings, but they have a pretty neat way where they all work on one live document together. So they're at the meeting just kind of typing, and as they're talking, they're putting things in this live document. So hats off to policy committee for being on point and getting that document, that live document. So at the end of that meeting, I'm going to say to y'all, they have like this working document that they share amongst each other, which I think is pretty fantastic. They have that to be responsible for. The board member handbook was also a task that was assigned to policy committee, and I removed that. Another committee is being convened for to create that board member handbook. That committee is comprised of previous board members who have sat on this board as a full term. They have the level of expertise to draft and put together a board member handbook. And so that is why this is on the agenda. So there's a new committee. It's called the Board Member Handbook Committee. I guess. The BMG, Board Member Handbook, BMH, the BMH. But again, they are comprised of previous board members who have sat a full term on this board. They can weigh in and give a level of expertise of what new board members need to expect and what new board members should follow, right, in their role as a board member. So with that being said, I will, I do know who the board member committee members are. And I know I'll make sure that I'll get that to y'all in writing, just to make sure that everybody who I did send out an invitation to has responded. But pretty much everybody has, but I'm not going to say that publicly until I can put that to y'all in writing. But that committee is being established.
Is that in the, we have another,
It's in a newsletter.
Thank you.
Yeah, so I mean, it is not the names. The people's names are not in the newsletter because the newsletter is already to print. Like you may get it in email between now and 2 days from now. It's done. The summer fall newsletter is done. So any questions about the BMH? Anybody? Any questions about BMH? All right. So with that, I don't think we have nothing else.
Oh, it gotta be something else.
No.
I'd like to make motion to add to the agenda.
Okay.
I'm just playing.
No.
So Jay.
So You was going to object?
No, we're not.
All right, so, with that, I believe that there is nothing left to discuss today. Thank you so much for your time. Thank you so much for, all the work that we do together, and, see you next time. At this time, we'll be adjourning the meeting. What time we got? 11:39 a.m.? So motion to adjourn, someone? All right, been moved by Evan to adjourn.
That's my need.
Don't have to, yeah, we don't. If it's unanimous, the meeting has been adjourned at 11:39 a.m. Enjoy the rest of your Saturday. Take care.
You know that.